We hear about non-compete agreements all the time. Sure, it makes sense that someone at Apple couldn't take all its trade secrets over to Samsung, but what's the difference between an enforceable and unenforceable non-compete agreement? The 1990 Texas case of DeSantis versus Wackenhut Corporation explores this very question. Edward DeSantis was a corporate security professional who began working for Wackenhut Corporation in 1981. Wackenhut provided security guard services to businesses, and DeSantis was hired to manage the Houston office. Upon hire, Wackenhut had DeSantis sign a non-compete agreement that prohibited him from competing with Wackenhut in 40 Texas counties for 2 years after he left the company, and from disclosing confidential or proprietary Wackenhut information. The agreement also stated it would be governed by Florida law. In 1984, DeSantis left Wackenhut and started Risk Deterrence Incorporated, or RDI, which provided security guards and security consulting services. About a month after leaving the company, DeSantis sent letters to 20 or 30 companies announcing RDI. About half were Wackenhut clients. In the letters to Wackenhut clientele, DeSantis included a disclaimer that he didn't intend to interfere with their Wackenhut contracts. After a few months, Marathon Oil, one of Wackenhut's clients, terminated its Wackenhut contract and signed on with RDI. Another Wackenhut client was considering doing the same. Wackenhut asserted DeSantis was violating his non-compete agreement, though DeSantis contended the clients moving over only became unhappy with Wackenhut's services after he left. In trial court, Wackenhut sued DeSantis with RDI for breach of contract and sought to enjoin them from violating the non-compete agreement. The court issued a temporary injunction against DeSantis, who then lost the Marathon contract. DeSantis then counterclaimed, and the court granted summary judgment for Wackenhut on the counterclaim. A jury determined DeSantis breached the non-compete agreement. The court then issued a permanent injunction against DeSantis, prohibiting competition with Wackenhut in a reduced territory of 13 Texas counties. The appellate court affirmed, and the state Supreme Court agreed to review the matter.